All right. Well, good morning, everyone. I've got a couple minutes after the hour, and we'll get things underway. Again, I want to thank all of you for joining us today on our update with navigating the Department of Labor fiduciary rule. My name is Tom Vukovich, and I have joining us today our President and COO, Lori Beck. And, hey, we have a terrific turnout today. I want to thank everyone for joining us. I'm sure a lot of you are drinking at least your second coffee after staying up late watching the election last night. So thank you for joining us at this early hour, depending on where you're calling in from. As always, we are committed to providing you with great ideas and tools to continue your business, as well as provide timely information that you need to know about. There have been a lot of questions ongoing. What are you guys doing to prepare? What do we need to do as producers to prepare? And hopefully we can address some of that here today, and we will continue to do that ongoing. During today's call, if you have questions, please submit them via the GoToWebinar, and we will do our very best to answer those towards the end of the call. Before I turn this over to Lori Beck, I just want to touch on three quick things: Congress, the courts, and our plan. And given the update or the upset of last night's election, we feel that there are clear indicators that Congress is against the Department of Labor rule. We feel, and we're hopeful, that this renews the possibility that this could be overturned by Congress. If you consider back in April and May, the resolutions that the Senate and the House passed that were vetoed by the President in June. So we certainly feel that this shows renewed possibility that this could be overturned by Congress. In the courts, legally, there are still 4 lawsuits that are out there that have not been addressed or ruled on yet. So that gives us something to look at also. And then finally, our plan. As Lori mentioned on our last call and at our summit back in August, we believe that hope is not a strategy. And we talked to a lot of different insurance carriers and IMOs, and a lot of them aren't doing much, and they feel like this is going to be put down. But we've never felt that hope is a good strategy. We've been operating under the assumption that this will go into effect on April 10th, 2017, and we're preparing to do that. So don't want to steal too much of what Lori's going to go into, but I'll turn it over to her shortly. And again, if there's questions that you walk away from today that you have, please reach out to your marketing partner. Email me, email Lori. We'll do our best to answer all questions today and ongoing as we move through towards the end of the year. So without further ado, I will turn it over to Lori Beck. Thank you, Lori.
Hey, thanks, Tom, and I appreciate the time this morning. And I thank everybody for spending some time with us today talking about this DOL rule. I'm sure most of us have stayed up late and got up early, and so I appreciate you spending the time. You know, we have spent a tremendous amount of time and effort and energy on this particular piece of, well, it can't be a piece of legislation really, on this ruling. And the reason that we've done that is that if you talk to industry experts, what you're going to hear is that in 35, 40, 45 years that these folks have been in business, this particular rule feels to them as one of the most sweeping changes to affect our industry in their history in the business. And so it's critical and it's important, and it's something all of us have to pay attention to. And, you know, we know you're getting barraged from a lot of people who are sending messages, and a lot of those are conflicting messages. Some of them are simply marketing tactics. They're coming out to you saying, hey, look, you know, you better align with us, because if you don't have a future in this industry. But in any event, you know, there are conflicting, somewhat scary messages being talked about in the industry. And we feel like our job to you is to not bring any scare tactics, to not bring any unrealistic, let's just be the turtle and hide in our shell, but to really bring you the facts as we know them. This is our third Department of Labor update. We expect to continue to bring these to you. Right now, we did one in September. We're doing this one in November. Most likely we'll bring you another one in December rather than waiting 2 months. So just know that we are here. We are going to bring you the facts. We're going to bring you the facts as we know them, and we're going to answer your questions as honestly and as thoroughly as we can, because as your partner in this, which we hope you consider us to be as well, we feel that's our obligation to you, and we don't take anything more seriously than our obligation to our customers. But let's be clear, this rule as written is going to change the way we all do business. From carriers to broker-dealers, registered investment advisors, banks, plan sponsors, advisors, IMOs like INA, we will all have to change some of the ways we do business if the rule stands as it is today. And I just got back with Tom and Jerry, and we went to a meeting at Allianz headquarters, and one of their key executives has on his computer one of those countdown clocks talking about how many days, hours, minutes until this rule goes into effect. And while I thought that was just a really stressful thing to do, I did look at that this morning to see, how much time do we have before 90% of this rule goes into effect. And as of right now, we have 151 days and just under 14 hours before this goes into effect. That's not very much time, folks, not for everything we have to do. And so what we believe we have to do is we have to hope for the best, prepare for the worst, and stay on course so that whether this rule gets overturned or not, we're ready for either scenario. And we want to make sure that you are as well. The thing we really want you to come away from with this meeting today is we want you to come away with some new information. But mostly we want you to hear this message again and again, and it's why we use this particular background in our PowerPoint presentation. We don't want you to ever feel like you're out to sea alone. We want you to know again today that we're talking about navigating these changes and doing it together. So we're going to provide you some updates on some things that we are currently doing to make sure that we will all be ready on a go-forward basis. And if I can get my slide to advance. There it goes. To do that, we want to give you as much information as we can and cover the most pressing things that are on your mind based on the questions that we are getting today. And we've covered some of these in previous sessions, but I want to touch on them briefly again for those of you who are not on the calls before, because I want to bring you all up to speed so we're at least all at the same level. So we're going to cover real briefly, how does this new rule impact you and your clients? Which products are affected? How this rule is expected to impact your broker-dealer, your RIA, your insurance carriers, or your IMO. We're going to talk about what your best next steps are. We're going to talk about when this impact is expected to hit you and your practice. And then something new we're going to talk about today and give you some updated information on is how does Insurance Network intend to adapt to comply to these new rules. So let's take a step back and get into what this rule is all about first and foremost. And to do that, let's talk about the timeline. This rule has been in the works for about 6 years. I remember going to Washington, D.C., which representatives of Insurance Network go back to Washington, D.C. once or twice a year to talk to congressional representatives about things that impact our industry and things that impact you. And I remember going back there 6 years ago and people were talking about this fiduciary rule, and I hadn't heard much about it and I really didn't understand it. But NAFA, the National Association of Fixed Annuities, did a pretty good job of keeping us up to speed. And so I started talking to people, and others within our organization started talking to other people there at Washington, D.C. 6 years ago about this, and every year since. But when did it actually come out? Well, in June of 2015, they finally came out with their proposed set of regulations to expand the Department of Labor's definition of a fiduciary. In April of 16, after a fairly lengthy comment period, the Department of Labor finalized their new regulations that expanded the definition of a fiduciary as well as provided new and amended prohibited transaction exemptions. And we're going to get into what that means in a few minutes, but I will tell you that both of those two things are very big, they're very important, and really are the most problematic parts of this particular rule. I'm very careful not to call it a law because it's not a law. This didn't go through Congress. This was a rule that came from the Obama administration to the Department of Labor. As it stands today on April 10th of 2017, Phase 1 compliance is required. And trust me, Phase 1 compliance is pretty extensive, and we'll get into what some of that is in a minute. But full-blown rule is January of 2018. You may hear a lot of talk about a BIC or a BICE, and again, we'll talk about what that is briefly in a minute. But that's really when those have to be signed, and that's really when some of the major liability is going to start kicking in, not only for the financial advisor, but also for their financial institution who is partnering with them on those transactions. So which are the affected plans and accounts? Well, pretty much any product that is part of a qualified plan. A lot of people were surprised to see that health savings accounts were covered under this, but really it is a pretty wide gamut of products, including any product to be funded with a rollover from one of these plans. And so, for example, there's a strategy that maybe some of you employ with some of your clients where you take RMDs, the required minimum distributions, out of a qualified account in order to fund a life insurance product to leave a legacy for loved ones that perhaps they weren't able to do with just using their assets as they were. Under the new regulations, because you are removing money from a qualified account to purchase life insurance, those transactions would also fall under some of the new fiduciary rule. But look, today, to try to keep this presentation to about 30 minutes tops and to focus on the accounts that most of you on the call today deal with, what we're going to try to spend our time doing once again is really talking about the impact to you when you're recommending rollovers from 401ks to IRAs, IRA to IRA direct transfers, and also opening up new IRA accounts. So let's start at the beginning. Does this rule even impact you? Well, who is a fiduciary under the new rule? The fiduciary can be a broker, investment advisor, insurance agent, or any other type of advisor who is receiving compensation for providing advice that is individualized or specifically directed to a particular plan sponsor, plan participant, or IRA owner for the consideration in making a retirement investment decision, is now going to be considered a fiduciary. Such decisions can include, but aren't limited to, what assets to purchase or sell, or whether to roll over funds from an employer-based plan to an IRA. I will tell you that that by itself isn't overly concerning. I mean, we should all be putting our client's best interest at heart, and so in general you would think that's not so bad, but it's always the devil that's in the details. So let's talk about that. You know, an important point to make today is that today an investment advisor is already subject to a fiduciary standard. A registered rep is currently subject to a suitability standard, and of course that's pretty much the same standard that applies to an insurance-only producer. This new rule brings fiduciary standards to the registered rep and to the insurance-only producer, as well as redefining investment advice. So this does impact the RIA and IARs, even though some feel it might not because they're already fiduciaries under the current rules. But let's look at what that means. So there's currently a 5-pronged definition for investment advice. It means making investment recommendations on a regular basis. There's a mutual understanding between parties that that's what you're doing. It is the advice that you offer is the primary basis for the decisions made, and they're individualized to that plan's needs or that participant's needs. But that's not what it looks like anymore. Now, it includes one-time advice without the regular basis condition. there is no longer a need for mutual understanding of the parties. The advice may address a particular investment needs or a particular investment decision, but it does not necessarily need to be individualized. And this bullet here is one of the ones creating a lot of angst with people, because if in fact you're just giving somebody some information and then they use it to make a decision, even a decision that you didn't have anything to do with, you weren't the guy out there who helped them make the final decision. If that goes bad, there are some that believe that they could come back on you. So not saying they can, they can't, I'm just telling you what some people in the industry are interpreting this to mean. Now, another bullet here is that the client only needs to receive the advice, and the advice does not necessarily need to be the primary basis for the decisions. And it expressly revises the definition to cover investment management recommendations. So it's a pretty robust, all-inclusive change in what they consider it to be. Now, here's the deal. What does it all mean to you? Well, once you're determined to be a fiduciary, using those standards we just talked about, you are subject to the fiduciary standard of care. And the fiduciary standard of care requires that a financial advisor act solely in the client's best interest. The word solely is really critical here. In addition, the fiduciary must disclose any conflict of interest or potential conflict of interest, which could include a lot of things, but it also includes variable compensation, in other words, commissions, bonuses, incentives, and other things that might have created a conflict for you when making a particular recommendation. Now, that's because we have also fiduciary prohibited transactions, and this is where all of you are impacted probably the most. When an advisor becomes a fiduciary under this new rule, the advisor's conduct is then governed by fiduciary prohibited transaction rules in ERISA and the Internal Revenue Code. And generally speaking, those rules prohibit advisors from receiving payments from third party, such as insurance commissions. Literally, those transactions are prohibited. Now, before you panic, the Department of Labor's fiduciary rule does include exemptions which, if their requirements are satisfied, would allow you to receive reasonable commissions. Note the word reasonable, which is in the rule but has not yet been defined. And these exemptions are 8424 and vice. I know I'm going through a lot of this pretty quickly, by the way. We are recording today's session. And part of why I'm going through this pretty quickly is, again, I know some of you have been on these calls before, and I didn't want to just really go in and kind of repeat the same stuff. So I hope you'll forgive me for that a little bit. But listen, 8424 is one of the exemptions. And the 8424 exemption has actually been around for a long time. This new rule simply expanded it, albeit they expanded it a lot. And in the proposed rules, indexed annuities were included under the 8424 exemption, but at the last minute was moved under the more onerous vice, which we'll get to into in a minute. And I will tell you that that move, that last minute move to take an insurance product from 8424 and to move it under this more onerous vice is the basis for many of the lawsuits that are currently still pending a decision in different courts around the country. But here's 8424. So 8424 says that if an advisor meets the requirements under this exemption, he or she may receive variable compensation such as commissions, but to meet the requirements for the exemption, the advisor must acknowledge in writing that he's a fiduciary and must agree to adhere to the best interest standard of care. This, of course, is already being done by those who are already considered to be fiduciaries. The advisor's statements cannot be material or misleading, and the failure to describe a material conflict of interest is deemed to be misleading. So if there's something that is later determined to have been a conflict of interest that you didn't disclose at the time, that would then be considered to be a misleading statement, and you could be in trouble with respect to the Department of Labor. The advisor must now disclose his compensation, something new, and any potential conflict of interest. Again, some of that is happening today in that world, some of it is not. A new rule: before the sale is finalized, disclosures must be delivered to the IRA owner in writing, and the IRA owner must acknowledge receipt of the disclosures. This one's a big one. The advisor's compensation must be no more than reasonable, and the advisor cannot receive any additional financial incentives. So even though on one hand they're saying you can have certain things as long as you disclose them, under 8424 they say not so fast, because trips, awards, and bonuses are absolutely prohibited if you're going to receive commission-based compensation. So let me explain what that means kind of in general terms. If you're receiving fees, you're a fee-based advisor, and you have disclosed these conflicts of interest, these trips, these awards, these bonuses, then you would be okay. Not so, not the same thing for anybody receiving commissions. And so this is different. Now, one of the things I want you to think about is, carriers are going to have to look at variable compensation offered to their agents and even to marketing organizations. And marketing organizations like INA, we have to reevaluate the extras we provide when you write qualified business with us. It doesn't mean we won't be able to host trips. It doesn't mean we won't be able to do these things or provide marketing bonuses for you. It simply means that we have to re-look at how you qualify. We have to re-look at what the primary focus of the trip is. And so we do expect that these things will change, but we do not expect our ability to do things for you as we do them today will go away. And I want to reassure you on that. We are committed to continuing to provide some of the things that we have done that have created the network of producers that we enjoy today. I've got to talk real briefly about the prohibited transactions exception, the BIC, the BICE, the whatever you choose to call it these days. It is the best interest contract. And one of the biggest reasons that this rule is going to take so much planning and so much restructuring relates to this BIC exemption. As I said before, originally it was expected that indexed annuities would be with all other insurance products sold, in other words, covered under the 8424 exemption. But the industry was stunned when the Department of Labor moved indexed annuities into the BIC instead. And the most significant reason is that this best interest contract must be signed not by the advisor and his client, but by a financial institution and the client. And that financial institution takes on a lot of responsibility, they have a lot of new requirements, and they take on a lot of risk in doing so. So there are 4 best interest contracts, and for the purposes of this audience, we're going to focus on the full-blown BIC, which will be required beginning in January of 2018, assuming that the rule is not changed in the meantime. So the full-blown BIC as it stands today is a written contract that must be executed at the time of the policy, and it must include the following. It's a pretty extensive contract, a lot more paperwork. It has to include the definitions and terms of the fiduciary standard of care. It has to have general disclosures for compensation, explain what different conflicts of interest are. It has to have specific compensation figures available to the client upon request. There have to be compliance policies listed for how to mitigate conflict. And perhaps one of the biggies is that mandatory arbitration is still a reasonable venue, but you cannot limit a client to only have an arbitration clause, as are in many insurance contracts today. Instead, you cannot limit the right to class action rights. This transaction disclosure, this BIC, has to be done. In other words, if you have a policy that is more than a year old and they're just dumping money into that product, you don't need to have a new BIC signed. But month 13, you do. And you're going to see products have to change and vary because carriers are not going to be in a position to go out and get a brand new BIC every time somebody adds new money to a product in year 2 or year 3. So we talk a little bit about this in a minute, but you're going to have to see some product modifications. And part of the reason you're going to see product modifications is because of this brand new BIC being required every time new money is dumped in following the first year. One other kind of side note is that whoever the financial institution is going to have to create a consumer-facing website focusing on the business model, listing the conflicts, and providing a mechanism for the investor to get more information if they need it. So again, who signs the BIC? Well, as we said, it's the policyholder, the investor, and a financial institution. Well, who is a financial institution? Well, a broker-dealer can be one, a bank, an RIA, an insurance carrier, and even an IMO if approved by the Department of Labor. But going forward, any advisor who is writing indexed annuities and other products that are included in this too. I mean, we're just talking about indexed annuities in this presentation, but it isn't just indexed annuities that fall under the BIC. But if you are writing these products, you must have a financial institution partnering with you to agree to sign that BIC. So if you are a registered rep, it's going to probably be your broker-dealer. If you're an employee of a bank, probably going to be your bank. If you're an IAR, probably going to be your RIA. Most insurance carriers are coming out saying we are not going to sign BICs. There are a handful who have said they will, many saying that they won't. And we can certainly give you our most up-to-date information on who is saying yes versus no. But then this last bullet is the marketing organization. In order to become a financial institution, they weren't written into the rule. What the rule said was that an IMO could apply, and there are about 13 organizations that already have. Many others have now held off, and I'll explain to you why those organizations might be holding off in a minute. But let's talk first about what that means to the financial institution that is signing that document with your client. Well, because it includes the private right of action in the future, excise penalties for breaches, and added scrutiny by the regulators, there's a huge risk to the financial institution that signs that document, given the fact that they are signing it on a sale they didn't witness. And it goes deeper than that. It's not just what happened that day that the advisor sat down with the client. It's how did they meet the client? Did you send out an email that they got? Was it something on Facebook? Was there a seminar that you put on? How did you get to the point of having that meeting with them when you made the recommendation to begin with? So the entire sales process, the entire introduction, well, really every interaction with your client can be called into question with respect to whether or not you did your proper due diligence and throughout the entire steps made sure you were acting in your best interest and made no material misleading statements. So what does that mean to you is that you can expect more supervision by whoever is signing the BIC, because it's the only way that a financial institution can mitigate some of that risk. And it also means that they're going to have rules for everyone involved in the sale, and some of those are providing significant documentation of the process. As Tom and I go across the country and we attend meetings and we learn more, the number one overriding thing we hear is technology, technology, technology. You have to have a paper trail in an electronic form. You have to have an audit trail. You have to have whatever you did with that client be auditable, defendable, right? So we're going to talk a little bit more about what that means in just a minute. So let's talk just kind of a step back about what the future might look like. Well, products are going to be more streamlined in the fixed annuity space and more creative in the fixed space. What I mean by that is because 8424, you know, where you don't have to have that BIC signed, where there isn't the class action lawsuit, where there isn't all of this additional scrutiny and excise penalties and all of that, the products in the 8424 space are going to get more creative. We're hearing from a ton of different carriers who are talking about products that will be specific to the 8424 space. So what does that mean? Probably it means MIGAs with really robust income riders, right? It probably means some creative ways to provide good interest credits that are not indexed in interest credits. So we do expect to see some of that. We also expect to see that some of these hybrid and perhaps more complex indexes that you see in the marketplace will most likely become less common. The expectation there is that it's going to be harder to defend if you become embroiled in some sort of a, you know, Department of Labor audit or some court case where a tort attorney is trying to figure out if you acted in the best interest. It's going to be harder to defend some of these hybrid indexes where they're backcasting dates that, you know, on an index that didn't exist at the time that they're backcasting them. And so remember we talked about material misleading statements? If those products don't perform the way they were backcasted and expected to perform, we expect to see some lawsuits come out of those. And so what we're hearing in the industry is expect products to become a little bit more simplified, and probably some of those hybrid indexes that you see on some of these carriers' products today. We don't really market any of the ones that I'm talking about here at Insurance Network, but I'm sure you're seeing them on a regular basis. Compensation for products is going to become more levelized amongst carriers and products. You know, this is a real tricky thing. You can't break antitrust laws. So it's not like the carriers can get together and say, hey, what do you think is reasonable compensation? We should all come out with a 5% compensation, because there are antitrust laws that prevent some of that. But at the same time, we do expect to see the industry kind of level out on all of this. If they don't, then if you are a registered rep, you might see your broker-dealer bring all compensation on these products in-house, run it through the grid, and do it on a levelized basis. The reason you might see that happen is that they don't want to have the argument, they don't want to have the battle of, well, the reason he sold product A over product B was because the compensation was 2 points higher. So we do expect to see some compensation change. I do want to tell you that that doesn't necessarily mean that commissions are going to go down. I've heard a lot of horror stories, a lot of fear out there that, oh my gosh, you know, everything's going to go to this 1% trail, or it's going to, you know, heaped commissions are going to go away, and we're only going to see 2–3% compensation. I'm not hearing any of that from any of our carrier partners. Most carriers believe that compensation, the 5, 6, 7, 8% range, can be considered reasonable based on the complexity of the products and the time horizon in which you are expected to service that client on these long-term products. However, that said, compensation that includes production bonuses is going to have to be modified. So we're going to be bringing you more information on some of the changes you might expect to see in 2017, especially if you are currently receiving tiered commission from a company like Allianz or are currently on their deferred compensation program, because their attorneys are indicating that they believe those products, that those bonuses, those deferred compensation, to create a conflict of interest. You know, if you're $20,000 away from a retroactive bonus, if you write a product with Allianz, you might be more inclined, according to a regulator, to recommend that versus the American Equity product that in their mind might have been more in their best interest, but you would have been paid more. And so we do have some changes we need to announce on that will go into effect in 2017, and your annuity marketer here at INA can give you more details on what we're hearing at this time. So what does the future look like for Insurance Network, and what does it look like for our dealings with you? You know, Insurance Network is committed to the future, and we are in the process of implementing 3 companion strategies, one for registered reps, one for the RIA-IAR space, and one for our insurance-only producers. And I want to assure you at this point that we are extremely well positioned to do this. We have the right team, we have the right financials, we have the right leadership, and we have the right producers and the right partnerships with the producers that we feel very comfortable in all 3 of these categories. But because each of the needs of each of these categories is different, we can't have one strategy for all 3. And so we're working diligently behind the scenes to make sure we have strong and competitive strategies in each of these spaces. So as I look at the audience list, I can tell we have people in each of these categories on the phone. And I'm not going to be able to go into real good detail. I think what we'll do in the future, we'll have a registered rep webinar, we'll have a conference call, we'll have one for our RIA market, and then we'll have one for our insurance-only producers so we can dig a little deeper on the strategy that we see for you. But for right now, let me just talk at a very high level. All of our companion strategies, whether you're in any of those 3 categories, are going to require Insurance Network to bring on new staff. We're currently looking for a new compliance officer. We are currently looking for a new marketing director who has a strong IT background to bring more different types of marketing to you and to us as we build out some of the things that we're going to have to build out, particularly on the IT side. And then we're going to need best interest assistance. If you have to operate in the best interest, you're going to need help and training from somebody to teach you a little bit more about what that means as defined by the Department of Labor. We're also going to be needing to bring on new software, and we're in the process of evaluating several different programs and different platforms, and as we know more about those choices, we'll bring them to you. And we'll also be talking to some of our key producers and running them by you and seeing what you think, because we're not going to do this in a vacuum either. We're going to do this in partnership with you. But some of the software that we expect to have, and everybody agrees is going to be necessary, is some sort of a client profiling program that you can enter in a very robust profile of your client that will then do, whatever it is that programs do in the background to take in a lot of different information and evaluate the needs of that client and kick back out to you, hey, based on what you said, here are the 3 products that would be in the best interest of this client based on what you entered. And then you will still have the ability and the right and certainly the expectation to recommend the one that you feel the most comfortable for your client's needs. So once we have all of those types of programs in place, then let's take a look at some of these companion strategies. In the registered rep broker-dealer channel, what I will tell you is that we do expect many broker-dealers to bring all indexed annuity sales in-house and no longer allow those to be outside business activity. I know that's disappointing to many of you who are currently operating in that fashion. But again, you have to look at it from the broker-dealer's perspective. If they're going to sign the BIC for you, they're going to have to supervise you. And the only way they can truly supervise you in what you're doing is to no longer allow it to be outside business activity. We expect broker-dealers to no longer allow any IMO of your choice to be the one you're placing that outside business activity through. So what we expect as most broker-dealers is to go back through and do new due diligence on the marketing organizations that they let you work with and probably narrow that down to a half a dozen that they will let be on their quote-unquote list. So we will be working with your broker-dealer to ensure we remain on their preferred list and meet the criteria that they set. We just had a great meeting with one of the broker-dealer relationships we have and ask them the questions, what do you need from us? What does it need to look like? How do we need to be sure we're providing you and your reps what you need? And we talked at length. Everything's great. we're going to be in good shape with this broker-dealer, and they expect us to be their preferred IMO. We expect to be able to continue to do that with your broker-dealer as well, but we may need your help to make sure we're talking to the right people. You know, we don't want to be talking to one set of people at your broker-dealer only to find out somebody else is making those decisions. So we want to keep doing business with each and every one of you, and so we may need your help in that regard, but we will be ready. In the RIA IAR channel, this is a unique channel, and so in this area, we're going to work with those of you in that channel on an individual basis to assist your needs and find the way to partner best with you on a go-forward strategy. Make sure we're providing you the infrastructure and support you need, assuming that you need it, and work to see what is the best fit for you. So if you're in this RIA IAR only channel, expect to have a conversation with us on an individualized basis so that we can together work out the best possible strategy. You know, that leads us to the insurance-only producer channel, and I will tell you that a significant amount of our business is in this channel. Many of you had been securities registered in the past and decided not to go that route anymore. Some of you are deciding to go into that path. Some of you are looking at becoming IARs, and we can help you with that. Some of you are looking at becoming registered reps, and we can help you with that. But if you want to remain an insurance-only producer, I want you to understand that we're committed to you as well. And in keeping with that, we will sign the BIC for those producers who will partner with INA in the post-DOL era. How do we do that? Well, it is our intent to become a financial institution under the Department of Labor regulations. We have not filed for that status yet. We are in the process and preparation of filing, and some very close advisors of ours, including some who have already filed with the Department of Labor, came back out to us and said, hold off, take a deep breath, don't do it, because the Department of Labor has come back and indicated that they are not going to individually name IMOs as financial institution. What they have indicated instead is they are going to provide you with criteria, and every IMO in the country that meets that criteria is going to be deemed a financial institution. And again, in working with these advisors, these attorneys, what we're hearing is, based on everything that we've discussed, we will have no problem meeting those requirements. And so it is our intention to become a financial institution. Do we have a backup plan? Of course we do, but at this point we are not concerned, and so we will be signing the BIC for those producers who partner with us in the post-DOL era. Remember that who that means, that's talking about qualified money and FIAs. You don't need somebody to sign a BIC if you're selling under the 8424, so the fixed annuities that are under that category. You don't need a BIC if you're selling non-qualified money. You don't need a BIC if you're selling life insurance. So this is a very narrow scope of producers, but a significant part of our business, significant part of your business, and so we want you to know that we are here for you. In addition, we will provide the platform to ensure your success. So again, you want to stay an insurance-only producer, we'll help you do that. You want to become under an RIA, we will help you do that. You want to become a registered rep under a broker-dealer, we will help you do that. Because we are committed to you and committed to the future. So kind of what's next? Well, what's next is we'd like you to reach out to your INA annuity specialist. Your team of advisors here at Insurance Network are ready to talk to you about your individual concerns. What does this mean to you and your practice? Expect to hear from us. We're going to be reaching out to many of you on an individual basis to get your input and to ensure that we're providing you the tools that you need going forward. It's critical that we do this together, and we're not going to do it in a vacuum. You are our partners, you are our customers, and we are absolutely going to do this with your input. But I want to remind you too that it's business as usual for now. I have a philosophy, and we talk about this a lot here at Insurance Network, that fear can either paralyze or propel you. And so this is a scary time. I mean, I would be lying to you if I told you there was nothing scary about this for you, for us, for the industry. It's a scary time. Some people are going to become paralyzed by that fear and do nothing. Don't be one of them. Be one of the ones that becomes propelled. Get engaged, get active, do what you need to do, partner with us. Our clients have never needed these products more ever in their lifetime. The markets are volatile, they're living longer, they need income that they can't outlive, and the only product in the entire industry that can provide that are the products that you're selling. So don't stop selling, get out there and talk to your clients, be propelled by all of this. And as you do, remember, we're in this together. Our job will be to keep you informed. We'd like you to keep us informed too. If you hear things out there you think we should know, reach out, talk to us, tell us. At Insurance Network, you have access not only to me as the President and Chief Operating Officer, you have access to Jerry Hartman, our Chairman of the Board and CEO. You want to call Jerry, he will take your call. You have access to Tom. If you want to talk to Tom on a higher level, he is there for you. But we have got one of the best teams in the industry when it comes to the annuity marketers working with you today. Talk to them, talk to us. Let us get you through this. Together we'll adapt. Together we'll grow, and together we'll succeed. I'm confident of that. There are times when this whole industry just gets scary and you're like, oh my gosh, what's going to happen next? I will tell you, I have never been more excited because this is our chance. This is our opportunity to set our path, and our customers have never needed us more. So let's make sure we're all engaged and ready to do that for them. I'm going to turn this back over to Tom. Sorry I went long. Those of you that know me know that it's really hard for me to talk in very short Reader Digest sentences, so I hope it was all okay. Tom, I've got our 800 number up there if they have questions, but certainly if you have a couple, we have a few minutes that we could take a couple of questions as well.
All right. Well, thank you, Lori. As I'm looking right now, there don't appear to be any questions. What I want to do is just do a quick recap and a few walking away items just to echo what Lori said. We are very committed to you and our business. We are ready to pivot into a number of solutions. We've been very engaged with this. We want to continue to communicate with you and look for another update in December before the end of the year, just to keep you in tune. We're going to continue to be very proactive on our strategies. And another thought is, with the mountain of information that is out there, there is certainly just as much misinformation and fear created. And so that's another reason why we want to reach out to you all, and we'll continue to do that. If you have concerns, reach out to us, please, and we'll answer anything. We'll tell you exactly what we're doing. And our view is that nothing really can happen in a vacuum. So we need your input as well along the way. We want to hear from you, and we want to hear your concerns. So hopefully this was helpful, and we'll continue to communicate to all of you any of your concerns. Let me see. I think we've got a question coming in. Just a moment here. And if we don't get to all of your questions, you hang up the phone, you think of something else at the end of the day, send me an email, send Lori an email, call your marketer. We are certainly here to answer whatever is on your mind. Just a moment here. I'm having trouble with the webinar. Isn't letting me look at the question here. Okay. All right. Doesn't appear to it. So I guess we'll end there. Again, if you have questions, you have our number. Reach out to us. We're here to help, and we'll continue to communicate as things evolve. All right. Everyone have a great Wednesday, and we'll talk to you all soon. Thank you.
Absolutely. Thank you again, everyone.